Well, you guys really suspended our house. Like 7:20. So there's no insurance.
That's smart. I like that.
Good evening. Yes, I will. All this meeting to order. We're welcoming some new members this week. So, I don't know, maybe just go down and I'll introduce ourselves a little bit. Start that one. Oh, shit. We have to push to the middle button on the top. Yeah.
My name is Adam Thomas. I live in District 3. And now I'm here just over a year ago. And really like the opportunity to be here to meet people, see what people of Inglewood want, and maybe help keep some of the integrity of the neighborhood together too. So thanks for having me.
Well,
I'm Andy Taylor. Live down by Jason Park. Been on this board for, I think it's 8 years now. I think I'm starting my 8th year. I think it's 7 or 8. Yeah.
I don't know how many we get.
I don't know how this is happening.
I'm 1 year longer than you. So.
Yeah.
I'm Jenna Ozels. I've lived in Inglewood since 2020, but grew up in Arapahoe County. Been in Colorado since the late 80s, and I'm very excited to serve this city that I live in, and I'm with you. I'm interested in seeing how we can preserve our community integrity and our spirit in the city. So happy to be here.
I'm Randy Friesen. I've been in Inglewood, I think, for about 14 years, and I've been sitting on this board for a year longer than Mr. Taylor. How long? Anyway, been vice chair for quite a while. With outgoing Chair Friesen with turnouts. That means running the show election for tonight, and then we'll have elections later.
Matt Collins, I've been living in England for about 5 years.
Broadway. Let's see.
Yes, on board.
6 months. Cecilia Anderson. I've been in Inglewood for about 25 years. And this is my first time on Board of Adjustments and Appeals, but I've served on other committees and I speak before many of them regularly.
Yes. James Thompson, I've been here about years. Some might be able to do it. It will be my last.
Welcome all the people. And our next order of business would be to approve minutes from December 13, which I think everybody got. I think there are.
We need to do a roll call.
Oh, I'm sorry. We'll do roll call.
Mr. Baker, Ms. Olsons, present. Mr. Thompson,
Present.
Mr. Taylor,
Present.
Mr. Collins,
Here.
Ms. Dickerson,
Here.
Mr. Cox,
Here.
Vice Chair Friesen.
Present. No. Approval. Peyton. Only 4. Take a voice vote. Well,
Somebody move to approve the meeting minutes.
I'll move to approve the minutes for December 13th, 2023.
Second. Any discussion about it? If not, favor say aye.
Aye.
Any opposed? All right.
We also need to approve the findings of fact for VAR 2023-013 for 4335 South Fox Street. I could have a motion for that.
I'll move to approve the findings of fact for case VAR 2023-013 for 4335 South Fox Street.
Second.
Any questions, discussion, notice anything?
Can you clarify with the attorney as far as abstaining? They actually abstained, they weren't at the meeting.
Still have a form with the abstain.
I think we have 4 of us,
Four.
right?
Myself.
Yeah, because people have stepped down, like, well, not stepped down, but Chair Finn, I mean, he's no longer present.
Shelley, as long as we have a quorum, the new members should abstain since they weren't at the prior meeting. Unless they're needed, then we can cross that bridge.
Okay.
So we're good. Okay. So if you were here, in favor?
Yes.
Yes.
Aye.
Anybody opposed? Okay.
All right.
We are here tonight for public hearing. Find my case number. For VAR 2024-001. Applicant is and owner Jenna Morris of 4009 South Pennsylvania Street, Englewood, Colorado 80113. The request applicant is seeking an appeal to the primary residency documentation requirements pursuant to section 5-31-3.A.2.D of the Englewood Municipal Code. I have verification of publishing. Did we have to do posting for this one or not? Okay. I did have verification of that emailed to me. With that, staff could be sworn in and give us a rundown. Okay.
Do you swear or affirm or that no lies of perjury that you will tell the truth in this proceeding before the Board of Adjustment Appeals?
I do.
Please state your name.
Eric Sampson. I'm Planner 2 with Community Development. So this is variance case 2024-001, and this is a waiver request for a primary residency documentation for a short-term rental application. Some of you have heard a case very similar to this a couple months ago, and it's pretty much the same situation here tonight. I'll fill in the new members. So basically, when somebody is applying for a short-term rental application with the city, they need to show, if they are in any of our residential zone districts, that they are the primary residents of that property. Otherwise, they're not allowed to operate a short-term rental. And so we require multiple documents to check the primary residency status. One of them is an affidavit stating that they are indeed the primary resident. And then the other documents are the first or the cover page of their 1040 U.S. tax returns, and then 2 other forms of identification or documents that show primary residency. When get ahead of myself. So when City Council was drafting the short-term rental regulations, they did think about a situation like this, and the applicants had recently purchased their home in December of 2023, and so therefore would not have a tax return that showed this as their primary residence until they filed their 2023 taxes. So in that instance, the board or council stated and put into the code that documents required by subsections B and C above may be waived if the owner establishes compliance is legally impossible in an appeal to the Board of Adjustment and Appeals. So the applicant has provided all other documentation to staff that they are the primary resident of the property. But again, since they purchased the property in December, they are able to provide that tax return cover page. So community development would recommend approval of this waiver request. And it's going to be basically based on for a year. In essence, any STR person who is licensed has to, when they reapply for their license on an annual basis, they need to resubmit all submittal documents again, including the most recent tax return. So if they're the applicant's tax return should show the 4009 South Pennsylvania address of their tax return by the time they apply for their license next year. And if it doesn't, then it would just be a denial from staff. So any questions for me?
Yeah, any questions?
Have all the required documents been received? Other than that, I didn't see anything about the affidavit that had to be filed, or a floor plan, or the insurance, or neighborhood agreement, or garbage, or parking, or inspection. Why hasn't it been provided to the board so we can make a completely informed decision? And why a waiver for a year?
Well, so the short-term rental license is only valid for 1 year. And in terms of the other items, I mean, staff is pretty confident that they have the other items needed for an application.
Well, I don't see any legal impossibility of submitting a redacted 1040 showing primary address on Pennsylvania for 2023, much less a waiver for a year, perhaps a couple of months, but they can file a tax return anytime after February.
I mean,
Yeah, right now we're doing questions for them, and that would be a statement and a review on our part.
Okay. Well, then my question is, why a year?
I believe that's what's written in the code. It's a 1 year renewal part.
Yep.
If we want to do something differently later, then we can talk about it during discussion. But to follow up on our question, have all the other documents been provided to you? Insurance and the homeowners association, floor plans, property plan, etc.?
No, we have not received a complete application yet because the applicant was waiting for tonight's hearing to see if they were approved in order to submit their application. But as far as I understand, and you may ask the applicants themselves, I believe they have other documents.
So if we approve the variance tonight, then they would still be required to provide that documentation to you?
Yes. All that's required for approval.
And that's your normal procedure with when you receive anything anyway.
Yep. Yeah, when we receive our short-term rental applications, staff reviews everything. If we're missing a document, it gets kicked back to the applicant to provide those documents. And I believe they get 10 to 14 days to provide those documents before we just deny it. So we want those documents at a time.
Okay. Any other questions? We might call you back after a while, but
no problem.
I'll let you go for now. Thank you. If the owner would like to come forward and be sworn in, we would welcome hearing from you a little bit.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes.
Please state your name and address.
Jenna Morse.
So we've read your letter and the accompanying documents. I guess is there additional information that you would like to provide to us, or anything that you would like to highlight in particular?
No, I think that Eric represented the case quite well, and we have other documents with us tonight if you want to see them, including the deed of the house and even a mortgage bill with our name printed on it with our address and other documents like a voter registration form too. So if you needed those documents tonight, I did bring them in person, but like Eric had said, I did not push through the other documents in the application just quite yet because I was waiting for the hearing tonight to go forward and pay the $500 fee and whatnot. So I was just waiting to hear what you guys had decided.
Yeah, we do have your warranty deed, I know, and your letter, and also your closing document. Any question for the?
Have you filed your 2023 taxes yet?
Yes, we just did last week. So that will be coming in hopefully, you know, by April.
Okay, so then theoretically you would have the cover page of your 1040 that you submitted a week ago?
Yeah. Yeah.
Okay, I have a question for staff.
Any other questions for the applicant?
Yeah.
Yeah, I think it probably looks kind of silly that we went through this whole process to do the tax stuff because when I originally filed it, it was back in, well, we bought the house in December and we had decided to do the short-term rental. And so then when it came to January, I just was a little bit slower with the application for the appeals. And then I just told my husband, Matt, tonight, we should have just waited to do the whole application until our new tax form came in. So we already paid the $250 for the appeals tonight. And I just wanted to be present and show up.
One other quick question. Is the address on your 2023 tax return the address?
Yes.
4009
yeah.
South Pennsylvania?
Yeah, it is all updated for this current year when we get the tax form back.
Thank you.
Mm-hmm.
And did you say you have that with you, a copy of that?
We don't have the copy of that back yet. We just filed those last week.
Any other questions?
Sort of. You have a copy, you would have gotten it, but you don't get a copy from the IRS.
Well, I'm not sure then because I did not.
If you had a tax preparer do it, you've got a copy. So you can submit it. So what you're saying is there's no need for a waiver.
Yes. I don't know. I don't do the taxes. Sorry.
I mean, if it's something that you've already filed and had a copy of, then we probably wouldn't need to have the hearing. So if it hasn't been filed yet, then we'd have a question for staff.
Yeah, can we just ask staff? Yep.
I think maybe that's all we have for you right now. We might call you back up.
Okay. Thank you.
Yes.
Considering that they have filed a 1040 for 2023, would they be able to submit that and not in that case then need a waiver?
Yeah, technically that would be correct.
Okay.
So I guess the question to us or to you is whether we really need to continue with this tonight or whether we just wait for that to happen.
Ultimately, that's up to the board. I mean, it is a waiver from the primary residency requirement.
I've got a question for council then. In that case, would it actually have to be withdrawn by the applicant, or would the board have to go through and deny the variance to clear out the case?
So I guess the applicant can always withdraw their application. I mean, that's always an option. But essentially what we're hearing is that the variance is, it's a moot subject. It's not an issue. If they could.
Well, just based off of the legal criteria, is the legal impossibility is no longer a condition. So I don't think we could pass it based off of the statute. And so in that case, the options would be theoretically, we might end up denying it or if the applicant withdraws it, then it's just a moot point. Correct?
Yes, yes, we're gonna get to the same conclusion. One way or another, the applicant can always withdraw their application. That's what they can do. The board can decide that it's no longer variance is necessary. Essentially, what we're seeing is that the variance is not needed anymore.
Right, and that's what I was just curious, is to clear it, can the board just wipe the thing away, or do we have to actually vote on it in order to clear that out?
Let me go ahead and look into that for you.
Okay.
I don't think this has come up very often.
Okay. He's gonna look into it.
I have a hard time hearing you, so next time that would be great. Any further questions for staff? We need to talk to applicant anymore or not? Shall we close the public hearing? Okay, we'll close the public hearing for VAR 2023-013, 4335 South Fox Street. Discussion.
We need a motion.
We need a motion, yeah, sorry.
Let's see. I'll move to approve the appeal to the primary residency documentation requirements pursuant to section 5-31-3 A2D of the Inglewood Municipal Code for case VAR 2024-001.
Second. No, we can have discussion.
I'll go first. So based off the statute, it specifically says that we can waive it if it is legally impossible in an appeal, and because they've already filed their 2023 taxes, it is legally possible for them to submit their 2023 application, which would mean that a variance isn't necessary. So I personally think we would either have to reject the appeal and then allow them to go through the regular process, or then withdraw their applications. Yeah, I don't think we have the criteria as outlined. I don't think there's a legal impossibility here, so I don't think I can't vote in favor of this. Right, we would have to either deny it or have them withdraw, and then just go through the stuff.
Did you have more to add, Councilman?
Yeah, without a withdraw in order to proceed with the process, the board would have to take action on their variance. So as has been discussed, if they don't withdraw, the board should just decide the matter based on the criteria.
So we would, if I understood you right, we would still need to approve it, or they would need to withdraw?
So if they don't withdraw their appeal, the board would need to decide the matter given the criteria that you're given.
So based off the legal criteria, I would have to deny the application because a legal possibility exists. But I think we should give the applicant a quick chance after discussing with staff if they would like to just withdraw it, rather than have a denial on the record.
Right.
Don't have a failed thing on their record tied to their property. They just have a withdrawn application on the property.
You may come forward again. Well, I guess that means we're reopening the case, technically. Yes.
We're gonna withdraw the application because when I did this, I didn't know we were gonna file the taxes. So I was just doing that on top area of like, if you do it, thank you. I just didn't know when we were gonna file the taxes, and so then when I just got here, I had an aha moment, and I was like, I just wasted $250 doing this. So that's okay. But
you wanted to see our faces.
I will say,
I did always wanted to step into the city hall, so I did learn and have a great experience. So thank you. We're going to withdraw from that, and we're good to go because we have our tax form with our current address on it.
I will say I at least appreciate you going through the process and trying to follow the rules and setting all this up.
Exactly, and we wish you luck with the short-term rentals.
And by the way, welcome.
Yes, thank you.
Thank you. So the case is withdrawn, and we can move on to new business.
So every year, this time of year, we have elections for this group to have a chair and a vice chair. So basically it's up to the 7 of us to nominate somebody we think would be good chair and vice chair. Have any nominations?
I nominate you for chair.
Second.
Can I say?
Well, you could, I suppose, but would prefer you not to.
I think,
Who's the second?
I'll need a second. No.
There was a double second.
Double.
Yeah, you got it. Anybody else that we want to do? I mean, I was going to suggest you, Matt, but
I would prefer not to be chair. I would be open to vice chair. I would be open to vice chair.
I'll nominate Mr. Collins as vice chair.
Second.
I would actually nominate Andy as chair.
What's that?
I would nominate Andy as chair.
I would also nominate Andy as vice chair.
I'm having difficulty hearing a lot of times. I prefer a little bit to not have to run the meeting because of that. So that was.
I would agree.
I would agree because I have not been able to ever understand you even as an alternate.
Would you be willing to be chair?
Or was there?
There was a second. Yeah, I seconded it.
Okay.
Yeah.
I'll entertain. Yes. If it's the. Yeah. I move to vote for Andy to be chair.
I say.
Okay. All in favor of Andy being chair? I guess we'll just go down one at a time.
Sure. Do we need a roll call or we just go down the line?
I think we can just go down the line, right? So,
Yes
or no?
Approved, yes.
Okay.
Are we doing chair now?
I'm sorry.
Chair.
Are we voting for chair?
Yep.
Andy?
All right. Yes.
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 Well, I nominated you, so I'm going to say no.
I nominated him, so I say yes. Plus, we have the same hairstyle.
Okay, I guess. And Andy will be the new chair then, 6 to 1. That brings us to vice chair, and you've been nominated.
I would nominate you as vice chair.
So you continue in the role.
Right. And as a supporting role and with
Mr. Collins wouldn't have his opportunity.
Next
year.
But he's a young buck. Yeah.
I would accept vice chair. Shall we
Can
call
I
for the vote?
move to, can I move to make that vote?
Yeah. That will be fine. We've had a second. So.
Second.
I say yes.
I'll say yes.
Absolutely, yes.
We'll say no just for the fun of
I say yes.
Yes.
6 to 1.
Yeah, I was going to say, I'll say yes.
All right.
So we have Taylor as chair and Friesen as vice chair.
You would?
Yep.
No, I think
So we're Mr. Taylor is chair and I'm vice chair.
That was a lot.
It was fun.
Yeah. No, I just think it'll be great moving forward. Great people involved, knowledgeable, obviously well in depth as far as, and we always get these odd cases. It's what makes, especially
that
you chair, Andy, and vice chair, to have the knowledge and expertise, I think is going to lead this board going forward.
Thank you. Should work. I understand that the city attorney would like to tell us how to be the BOA. We can learn all about it right here.
Evening, board. For those who don't know, my name is Adjourn. I'm the assistant city attorney. And I'm not here to tell you how to do the board job. I'm just here to give you guys a refresher. Yes.
Please speak into the mic because I didn't hear a word you said.
Okay. I'm here to just give you guys a refresher, not to tell you how to do your jobs.
You can tell me how to do my job, so that's okay. It's my first day.
We'll get into it, but I actually can't.
Okay, touche, fair enough.
Okay, so just a quick refresher. Now that you're part of the board, the Colorado Opens Meetings Law applies to you. What is the Colorado Opens Meetings Law? It's just a state law that requires a local government body to discuss public business, or that whenever they discuss public business or take formal action, that it happen open to the public. What does that mean for you guys? It need to know what constitutes a meeting. It's any kind of gathering, convened to discuss public business, whether in person, by telephone, electronically, including email, Zoom, and all that other stuff. Anything that involves policy making is open to the Opens Meetings Law. Okay, so that includes electronic communications. Conversations between a quorum in which business of the body is discussed or where formal action is taken are open to meetings laws. That means watch out for group text messages between all you guys. Can you hear me? Let me know if you can. Just raise your hand because I'll step away from it.
I do have a clarifying question on this. Based off of recent cases and things that have gone on, is it a quorum in which that applies to, or is it any communication between members discussing?
We'll get to it. Some questions might be answered during the presentation. Don't put a bookmark on that. So it includes engaging in phone conversations, Zoom team meetings, group emails. So when somebody puts everybody on an email, that's may be subject to the open meeting laws. Now, meetings have to be noticed. Per city policy, the meeting notice has to be the Thursday by noon, the week before the meeting itself. State law says it has to be at least 24 hours in advance notice, but per city policy, it's noon the Thursday before the meeting, and staff prepares all that. And you can always reach out to staff if you have any questions about the agenda and all that. Now, the notice needs to be written in a way where a lay person would understand where the meeting is and what's being discussed. Now, what does not constitute a meeting? Chance encounters or social gatherings. So if all you guys see each other at the same place at the same time, as long as you don't discuss business of the Board of Adjustment and Appeals, it's fine. Now, you need to watch out for 2 or more members. So 2 members can talk to each other. 2 plus or 3 and anybody else, that's when meetings need to start being open to the public. So chance encounters, you guys all go to the same place at the same time, that's fine. You just can't talk business. Now, Colorado Open Records Act, or CORA. It's a requirement that most public records or business of the government be open for inspection to the public upon request. What constitutes a record? Most writings maintained or kept by public officials as a public record. That content must be discussed in a public matter. So, I mean, if you guys are sending emails between each other, that could be subject to a CORA request. Just putting it out there so you guys are aware that public business that's reduced to writing is open to CORA. Other things that are open to CORA, the kind of the proceedings that happen here. They're published on the city website, but someone could also request them. A quick rundown of Bob's Rules of Procedure. In your agenda packet, there is the full Bob's Rules of Procedure attached if you guys need a refresher. If you guys want to see how it goes down, just watch other boards, especially city council. They use the Bob's Rules of Procedure. So what are Bob's Rules of Procedure? A simplified set of rules suited to manage local government meetings, like this. Bob's rules of procedure are not the more formal Robert's rules of procedure. That's why it's called Bob's. General provisions under the Bob's rules of procedure, recognition by the chair is required to address the body. It's called having the floor. The time limit on the floor is 5 minutes, can request additional time. A member may only speak once to any motion until all others have had an opportunity. No interruptions or side discussions. All motions received must have a second before debate can begin. And the chairperson may deviate from the rules if necessary to increase efficiency. Now, some motions. Motions must have a second. There's 3 main types of motions: privileged, main, and subordinate. There's also points. Points are types of motions or privileged motions. And there's 4 types of points: points of information, to request information on a specific question; points of order, basically that the rules are being violated; points of appeal, challenge the decision by the chairperson about the rules of order; and a point of decorum, review the act of a member. Sorry, the clicker likes to skip slides. So points and motions must be dealt with in priority order. First priority, privileged motions. Privileged motions are all point motions, motions of recess, motions into executive session. Second priority, main motions, motions formally present to the body or an item for action. And third, subordinate motions. Subordinate motions are motions to amend, continue to a date certain, or call a question. Now, as the Board of Adjustment and Appeals, you guys are known what's known as a quasi-judicial board. What is a quasi-judicial board? Here's the long legal definition of a quasi-judicial board. Quasi-judicial action generally involves a determination of rights, duties, or obligations of a specific individuals on the basis of the application of presently existing legal standards or policy consideration to pass or present facts developed at a hearing conducted for the purpose of resolving a particular interest in the question. This type of decision-making is denominated as a quasi-judicial precisely because it bears similarities to the adjudicatory function performed by the courts. So what does that mean? It means that you guys act like judges. So the board is essentially acting as judges, applying the city's code or existing law to the applications of people seeking variances. As a quasi-judicial board, some things matter for your guys' positions. Essentially, the board members cannot discuss a quasi-judicial matter outside of the public hearing. So this hearing, like we had the brief hearing we had today, this is where the matter is discussed. Ex parte communications are prohibited in civil and criminal cases, and it's prohibited in quasi-judicial matters. Ex parte communications are communications that board members would have with involved parties outside of the public hearing, such as if a board member had a discussion with the couple before the meeting, or I don't know, saw each other walking in the parking lot and was like, hey, board member, let me talk to you. So ex parte communications, third-party contact with involved parties is prohibited. The rule is designated to protect the rights of all parties, and quasi-judicial proceedings must be conducted in accordance with judicial due process. So the applicants have a due process right, essentially to have their application heard, and then you guys to decide the matter in an impartial manner. Some other don'ts: don't make up your mind before the public hearing until all evidence has been heard. Cannot help individuals through the process. If somehow an individual knows that you're on the board and they try to ask you for help, can't do it. Can't recommend people what to do or give them advice how to proceed through the process. Cannot discuss applications outside of the public hearing. Cannot have discussions with involved parties outside of the public hearing, and must disclose any conflicts which may exist. Financial, personal interest. Is it your neighbor? Are you going to somehow financially benefit from a variance or denying a variance? I don't know, do you just not like the person? You know, stuff like that. So some more: cannot be a witness at the hearing. Can only discuss the matter at the public hearing. Don't meet with applicants outside of the public hearing. Advise people that you can't talk about the matter. You can direct them to our city website, which has a lot of information, and you can also direct them to city staff. Like the member, like Eric, the members of community development. That's what they're here for. Well, one of the things they're here for. Due process is denied to parties when there's ex parte communication. That matters for a reason. There's also avoid the appearance of impropriety. meaning you're not necessarily doing anything that's contrary to the rules, but it doesn't look that way to a reasonable person. Now, the city code does have a code of ethics. The code of ethics does apply to board members. It provides for, gives you a purpose and authority, the rules of conduct for board members, gifts and other free stuff, and then also prohibits the appearance of impropriety and disclosure of recusal procedure. So board members are required to disclose if they have a conflict of interest. It also goes in there and provides that another board member can move to forcibly recuse a board member, such as if a board member didn't disclose a conflict that another board member thought they had that could be thrown out into the public meeting for action on the board. Those are the provisions. Look it up in the code. Does anyone not know where to look up the municipal code? It's okay. Everyone knows where it's at?
What did you say?
Not know where to find the municipal code. Just in case, you just Google Inglewood Muni Code. It's all there. New provisions are not added into the code right away. So if council passes a new ordinance, those are usually at the top, not incorporated in the code yet, just for anybody who's ever went looking into something that they thought should be in there. So the decisions that the board makes are quasi-judicial decisions. If you guys make a decision and someone doesn't like that decision, they can appeal to the state court system. So if someone is denied due process, they can appeal based on what they thought was their denial of due process. That's why it's important to take this seriously, because someone can appeal a final decision from the city boards to the state court system.
So does it automatically go to district court? I thought in this case it went to city council.
So if the board makes a decision and the person doesn't apply with it, it's known as a final decision, which means that they can kick it up, they can appeal. It would be a 106 appeal under the rules of civil procedure, which it's boring, we don't need to go into that, but yes, it would go straight to district court. But it's okay, it's just informative. No one's gonna do that.
Thank you. Now you jinxed us.
I'll be upset with you guys if that happens. Did you have a question, Mr. Cox? Okay, sorry, I thought I saw your hand up. It's in the packet. You don't have to take notes. Did you? Yeah.
Yeah, the slide showing and just sort of having my things, and I realized I'm not doing my laptop for these meetings.
Yeah, no, it's okay. I'm a handwriter too. It's all in the packet. Also included in the packet is the rules of conduct and the Bob rules of order in there, but I'm trying to think of the code of kind of like the little book of how to be on a board that the city has. Okay, so hearing procedures. This is citing to the new Rule 16, what a lot of people know as Code Next. It provides in there the procedures for a hearing. 1621G provides for the public hearing procedure. 1621F provides for the notice procedure. 1621I is for the appeal procedure. This is citing to the new code. It's a possibility. So the new code was passed in October of last year. Anything that comes before then is by the old code rules. Anything that comes after the code was incorporated into the meeting code goes with the new rules. It's still kind of confusing. I wish Eric was here to tell us if there's anything out there pending from the old code. Now, the procedure rules, there's other procedure rules in the code. City Council Manual and the City Code provides that all quasi-judicial hearings will be held under these provisions. 110.2, 110.2.1. These are much more detailed than the rules of procedure under Title 16. Title 16 provides the basic procedure, but these rules provide a much more detailed version of the procedures. And they importantly say that the rules of evidence don't apply at these hearings. Now, going to what the board is doing after it hears a application, findings of facts. What are findings of facts? It's generally apply facts to legal criteria. So you take what the applicant, what staff tells you, and you apply those facts to the legal criteria, which is the set that we were talking about earlier. And then you take evidence on why the action was taken. So it's important to detail why we did X because of. And it also makes appellate review easier. That's where that, if I'm not happy, it's a final order that can be appealed. And you guys back up your decisions on why things were done. Findings of fact should explain to the reader how and why the city reached its decision. It should include and identify legal relevant criteria, such as the standards that you guys are going by, explain the relevant facts relating to the application, and then apply those facts to each criteria. In conclusion, it should just be relevant legal criteria, explaining what you guys did, and applying those legal criteria to the facts to reach the conclusion. And then the Board of Adjustment and Appeals is actually founded and given its power through charter. Here's a long provision in charter, but the good part is the board shall have the power to hear and determine appeals from refusals of building permits and make special exceptions to the terms of the zoning regulations in harmony with the general purpose and intent, authorize variances from the strict application of regulations in such situations and subject to the limitations as may be set by ordinance. The findings and decisions of the board shall be final and subject only to judicial review. Here are the provisions located again in the new Title 16, or what is code next, 16.210, zoning variances. A, applicability, B, review criteria, C, review procedure, and D, effect of the decision. 16.211, administrative adjustment, again, A, B, C, applicability, review procedures, effective decision, and then 16.212, the appeal. Applicability, criteria, review, and effective decision. The Board of Adjustments and Appeals was created with the authority of Chapter 59 of the Englewood Home Rule Charter. The board has the following responsibilities under code. Hear and decide on appeals from denial of a building permit. Hear and decide on appeal administrative decisions made under this code when a clear error is alleged. Grant variances is a standard code. Any other items specifically delegated to the board by the provisions of this code. Now, here is, okay, went too far. Sorry. The name of the book in there I'm lost it. And I have to find it. Are there any questions for anybody?
I did see that zoning was mentioned in there. What's the line between planning and zoning then in this board?
So the Board of Adjustment and Appeals essentially decides the matter once the city has made a decision. So a permitting, a land use decision has been made, or someone wants to, like the application today, that one was kind of carved out. More like the last one I remember where the gentleman wanted a temporary structure over his vehicle, something like that. So it doesn't allow it. He saw a variance to try to permit him to have a temporary use structure put up. So, Board of Adjustments and Appeals is more dealing with people's rights when the code says one way. Zoning and planning is more planning everything, doing AUDs, PUDs, stuff like that.
Okay, so as far as like if somebody wanted to use something that the city had said no, that's out of zone, if they appealed that, it would go to planning and zoning. Or would it come to this?
So if they wanted to do something that wasn't within the zoned area, it would come here. Any other questions? Nothing else? What's important to know is that staff is here to back you up. Community development, Shelly, Eric, Brian, who's not here today. If you have any questions, feel free to reach out. My office is here to help you guys out. If you have any legal questions, and the book is named The Handbook for Members of Boards and Commissions. I just couldn't think of it. That's in the materials. So if you have a question, look at the handbook. Chances are that the handbook is going to answer your question. Bob's Rules of Orders are in there. Feel free to print them out and carry them with you. I don't have them memorized. I don't know who does, unless you do this all day. This isn't a speed contest, so feel free to take your time, look at materials. No one's rushing you. My office is here. City Attorney Tamara Niles, Deputy City Attorney Vicki McDermott, and myself. Feel free to reach out to us if you have legal questions. I'm here. Yes.
I do have a question. Somehow I've got two handbooks. One of them has a date of 2023 on it, and the other one, which is a more recent one. I don't know when they came in. I don't know how I got two. But which one? Is there any difference between these two?
I'm not aware of another version of the handbook. Shelly, are you aware of another version of the other than the 2023 one?
Yeah, I'm not sure which. I'll look at it.
Do you mind if I take a look and? So staff is here to help you with the everyday kind of running of the board. If you have any questions, if you have legal concerns or legal questions, you can come to me. Feel free to email me. Anyone who doesn't have my email, let me know.
My other question, some of the stuff that we have related to short-term rentals, those are in title, or which chapter are those?
Those are in Title 5.
Title 5.
Title 5, Chapter 31.
Okay.
It's essentially city council regulated short-term rentals, and they carved out like the purpose as ordinance may provide. They've provided the Board of Adjustments and Appeals can decide those decisions. Okay. So they've given short-term rental license applicants a way to appeal if the city denies their application.
Thanks. I can just never remember what title that one's in.
Out of curiosity, just from a procedural standpoint then, does that mean that before it comes before the board, it's been officially denied by the city?
If someone is seeking a variance, then yes, they would have had to submit an application to the city, which would have been denied. The short-term rental is like, it's like a carve out that they made specifically for that. But generally they want something is not going, they're not complying with whatever the city wants. They want you guys to appeal, decide, or variance it.
Okay. Yeah, I just didn't know if the city had to take an administrative action before it came.
Yeah, that short-term rental one, it seems that they were waiting for that.
Outside of short-term.
Yeah.
So we say submit an application to the city. Does that go in front of the city council first, or does it go to a clerk? References code, or
depends what the application is, but generally community development, who Eric is a part of that department, they take a lot of these actions that bring stuff to the board.
Yeah, and you'll see usually they give us community development does a brief before I think every single one I've looked at in the 6 months I've been here.
In terms of as we're doing like a public hearing and let's say the applicant's receiving questions from the board, I think one of the things that I've been counseling on is that we should avoid discussion during that period. Is that like a procedural thing that we need to wait for like a motion to be on the table before we start our discussion after the testimony is clear? I'm just trying to clarify like the order of things, because sometimes I think we kind of devolve from questions into discussion sometimes without
yeah, so if you actually look at the Title 1, Title 1, Chapter 10, it like provides like a 1, 2, 3, 4 kind of process. And Title 16 to a lesser extent kind of provides like a road of this is what we're gonna do. The Bob's Rules of Order are there to keep order between the entire board so that you guys aren't talking over each other. Everyone has an opportunity to talk. There's kind of an orderly process. And yes, side discussions while people are presenting shouldn't be happening. Did I answer your question or just make it more confusing?
No, I think just what I've received guidance on in the past is like someone may be asking questions to the applicant, but then it turns into just making statements and not actually asking questions of the person testifying or the applicant or.
Yeah, so an important thing of the chairperson is to keep order of the meeting, to make sure that there's an orderly function through the proceedings. That's an important role of the chairperson, to make sure that everyone during the meeting is holding complying with procedure. It's also important for the chairperson to the chairperson can warn individuals in the crowd if they're not complying with the rules.
Thanks.
This kind of gives the outline. That's the one he was talking about on the 16.2.1B. So that's kind of what Tom and I have been using.
Any other questions?
I hear none.
All right. Well, welcome new members. If you have any questions, feel free to reach out to me. If I don't know the answer, I'll ask someone who does.
All right. Thank you. So, I see no staff, so I guess we have no staff choice. If we have attorney's choice, he just made it. Any board members items needed to talk about?
Do we know if we have a case next month?
Yeah, I don't
Shelley
know.
might know.
Shelley, do we know if we have a case for next month?
We do not.
Okay. I will adjourn this meeting then. Thank y'all.
Thank you.
Thank you, everybody.
Everybody else has to make a motion. Yeah, if you don't find that in the